Hi, and welcome back to my channel. Today's topic is what not to include in your will. It seems we always hear, you should have a will. A will is so important. Things won't go the way you want if you don't have a will. And that's all true. That said, we need to keep in mind that the purpose of a will is actually somewhat limited when you consider it in the context of all of the important end-of-life issues and concerns. That is, the purpose of a will is to direct the transfer of your assets, identify the person you wish to be responsible for handling your estate, and, if you have minor children, to name the legal guardian. That's it. It may seem like it would be convenient or efficient to capture all end-of-life decisions in one place. However, legally and practically, one document just cannot do it all. So, what does not belong in your will? A will should not address detailed distribution of your personal belongings, your stuff. Assets which already have a beneficiary designation in place, such as your retirement accounts, life insurance policies, and hopefully all other assets. Assets titled in a trust. Assets owned by a business entity, such as a corporation, partnership, or LLC. Most jointly owned assets. And, very importantly, anything related to healthcare decisions to be made on your behalf, including consents or objection to organ and tissue donation, and directions for handling your physical remains. Let's take a minute to look at each of these things. I can discuss why it's problematic to include these in a will, and then give you other better options to consider. Starting with the personal property or your stuff. If you would like a certain person to receive a certain item of yours after you pass away, you should designate that on a separate writing authorized by your will. The separate writing is an informal document which you can update throughout your lifetime with no need of a notary public. If, for example, you generally want your children to inherit everything, except you would like your niece Julie to receive your dining room table and chairs, your separate writing would look like this. Then, let's say, in 5 years, your niece Julie tells you that she's purchased the dining room table and chairs of her dreams, but she knows her sister Jane would love your furniture. You would simply update your written list. If, on the other hand, you had provided that Julie was to receive your dining room furniture in your will, any change would require an amendment to your will with all of the signing formalities. This, of course, is inefficient and very expensive. Aside from your stuff, let's think about the other items that a will should not address. Let's start with titling. Holding assets in joint tenancy with a right of survivorship, especially for spouses, is generally very good in the sense that the assets will not be subject to probate when you pass away. However, sometimes titling can trip us up. Many people do not realize that the titling of assets will take precedence over any language in your will. Titling reflects ownership, and your will can only distribute what you solely own. So, for example, if your house is owned by you and another person as joint tenants, it does not matter what your will says about the house. When you pass away, title will legally transfer to the surviving owner. Similarly, if you have a trust and you have already titled certain assets in that trust, then your trust owns those assets. Because the trust holds title, not you, any language about those assets in your will is ineffective. Now, there are often excellent reasons for using a trust to manage the distribution of your assets, and I recommend them for many clients. But you just need to keep in mind that the trust language, not your will control who ultimately receives the assets owned by the trust. Another asset is property that is actually owned by a business entity, such as an LLC or an S corporation. A common example might be rental real estate. Let's say you have an LLC to own and rent out several residential properties. Any disposition of those properties in your will be ineffective. That is because you actually own membership interests in the LLC, and the LLC, not you, owns those properties. You can transfer your membership interest, but it's generally desirable to have that transfer happen through the LLC operating agreement. So the strategy with business assets is to ensure that the legal documents controlling the business include provisions for who will receive your interest in the business in the event of your death. This not only avoids probate, but it optimizes the chances that the business interest will be held by someone who can continue to operate the business successfully. Moving on to talk about certain financial assets. At first blush, it can certainly seem like the will is exactly the right document to cover all financial assets. However, without getting too deep into the weeds, a will deals with only your probate assets. Retirement accounts, insurance policies, and annuity contracts, when these are set up correctly, these assets should all transfer by beneficiary designation. Valid beneficiary designations will take precedence over the terms in a will. Confusion and conflict can arise if the language in the will is in any way different from the beneficiary designation. As an example, let's take a look at retirement accounts. These are also referred to as qualified assets. Here I'm talking about traditional IRAs, Roth IRAs, employer plans such as a 401k, 403b, 457 plans, any type of retirement account. With these retirement accounts, you will always have the option to name or list out your beneficiaries, that is, the people or organizations you wish to receive your account after you pass away. If you're married, state law or the employer plan may require you to name your spouse, but other than that, you may name whomever you choose. If you do not complete your beneficiary designation, the plan or account contract may have certain default beneficiaries. Any of these beneficiaries will be entitled to the account regardless of what your will says. So let's say that you wish to make a charitable donation by having your favorite nonprofit organization receive your IRA. And you document that in your will with the statement, I hereby direct that my IRA account number 1234 held with XYZ brokerage firm shall be distributed in its entirety to Habitat for Humanity. If you have a beneficiary form that lists the Humane Society, the language in your will have no effect, and Habitat for Humanity will receive nothing. Similarly, the beneficiary designation on a life insurance policy will control who receives the benefits or proceeds, regardless of what your will says. Very recently, I had a case in which a decedent had a significant life insurance policy which named his 2 children as the beneficiaries. However, in his will, he stated, I direct that the proceeds from my life insurance policy be used to first pay off any mortgage on my primary residence so that my spouse may continue to live in the property, with any remaining balance being shared equally between my surviving brothers. His children, the named beneficiaries, will receive the death benefit, and they will have no obligation to either pay off the mortgage or give any of the funds to the decedent's brothers. The language in the will have no effect. Again, the better option would be to design a beneficiary designation that would pay out the benefits in a way that accomplishes the decedent's wishes. So, generally and overall, the best way to proceed is to make sure that your beneficiary designations are completed as you intend, and then you should review them periodically to make sure that your current wishes are reflected. Same concept applies to annuity contracts. All right, now let's talk about any healthcare decisions to be made on your behalf, including your wishes regarding starting or ending extraordinary life support measures. Legally, a will, your last will and testament, is simply not the correct document to guide medical decisions and care. In Minnesota, a healthcare directive is now the legally valid mechanism which combines a healthcare power of attorney and the elements of a living will. The healthcare directive names someone else to make medical decisions for you and provides an opportunity for you to state your wishes regarding your own health care. As a practical matter, a person's will is not always easily accessible. So if your healthcare wishes are contained in your will, it is very likely that the right people will not be able to easily put their hands on the will when the time comes. This is never good, but it is especially stressful when the situation is urgent and timing is critical. The better option, complete your healthcare directive. Make sure that your healthcare directive is on file with your primary care doctor or clinic, as well as any specialists. Your directive should be included in your medical records. Give a copy of your healthcare directive to the people you name to make decisions on your behalf. Maybe send them an electronic copy as well. Keep a paper copy in your house and tell people where they can find it. With regard to organ and tissue donation, time is of the essence. Action must be taken very shortly after someone has died. There is no time to try to find the will and read through it to determine whether donation is desired. Again, completing a healthcare directive is an excellent way to make your wishes known. When somebody dies in a hospital, hospice house, or other facility, the healthcare directive should be readily available, allowing decisions to be made. Also, while you can of course indicate that you're a donor on your driver's license, the directives that I draft for my clients allow you to be much more detailed regarding donation. For example, some clients wish to donate only their eyes. Others want their donated organs to be used only for transplant and not for research. As a side note, if you are really interested in donating your body to science, I recommend that you contact a local medical school to ask about the process. For example, I know that the University of Minnesota has express requirements, and generally full body donation must be arranged during the donor's lifetime. Another item that doesn't belong in your will, instructions for handling your physical remains, your body, or your wishes regarding having a funeral or another type of memorial celebration. Generally, the choice of burial or cremation and any decision about what type of service may be held will be made relatively quickly after a person has died. Again, the will may not be accessible in time, especially if it is stored for safekeeping in a safe deposit box. The healthcare directive has space for you to set forth your wishes with regard to the handling of your body and any services to be held. Another option is to work with a funeral home to formally pre-plan and possibly even prepay for the disposition and funeral arrangements. You could also simply write up a note or letter about what you would like to have happen. Give copies to the people who will be handling these things and hope for the best. I believe most people are grateful and relieved to have some direction from their loved one. For the things that I've just discussed, healthcare, donation, and final disposition, there's nothing illegal about including them in your will. However, it can be both ineffective and inefficient to do so. To wrap up today's video, I'd just like to emphasize that a will is important, and yet it is just one piece of a comprehensive estate plan. If you have questions about any of the items discussed today, or if you are interested in beginning your own estate planning, I'd love to work with you. Thank you.